Kale is our first presenter. He's, of course, as I mentioned, here to talk about the surface and subsurface management. Kale Van Bruggen is with Rinke Noonan Law Firm, which is primarily based in St. Cloud, Minnesota. He concentrates his water practice, his law practice on water resource management, on agricultural law and environment, and other natural resource issues. Kale primarily represents clients in regulatory and litigation matters with respect to NRCS, certified wetlands, Clean Water Act, and wetland banking and mitigation. He also is spending a lot of time, certainly recently, in compliance with U.S. Fish and Wildlife Service easements and the recent issuance of possibility of appealing some of those easement areas. So I know his name has come up a lot in a lot of circles with respect to the wildlife easements, waterfall easements. He works in Minnesota on Wetland Conservation Act, Public Waters, Public Water, Wetlands, and Buffers Law. He also represents water resource districts and local governments in Minnesota and North Dakota on water management and drain systems and water quality enhancements. Kale is actually a North Dakotan initially, grew up near Litchville, graduated from NDSU with a degree in business administration and a law degree from Drake University. He started with Rinke Noonan in 2012. So hopefully, Kale, we're able to get your screen shared and be underway, but thank you for joining us today, and thanks for working on this presentation and offering your thoughts and
Thanks,
ideas.
Thanks, Jack, for also inviting me to speak, and for the Water Resource District Association for hosting these. I've been to some of these in the past. I think they're great events, and if nothing else, they're a great opportunity to bring people together and ask questions. So Lance or Julie, can you just confirm that you can see my screen okay and you can hear me okay? All right. Well, thank you, everybody. The topic, surface and subsurface water management, it's pretty broad. I tried to focus on areas that I thought may be of most interest to water resource district managers and their consultants. So some of the topics I want to try to cover in the just shy of 90 minutes here that I have with you are to start by going over some of the common law property right decisions that where courts or where judges have decided or resolve disputes between neighboring landowners over the management of their water. That'll really lay the foundation of everything that we talk about after that to build off of it. We'll talk briefly about how maybe you can mitigate the risk of letting a judge decide your case through drainage easements, and as Lance mentioned, we can talk briefly about some conservation easements. Primarily, I've been working recently on U.S. Fish and Wildlife Service easement disputes between landowners and the government over the scope of those easements. We're going to go over some land use controls. Going to, at a high level, talk about some public water management statutes and processes, and then finish up with some environmental regulations. Some of the goals I have is I want to identify the North Dakota law on these issues, but I've been asked, and more recently, I think as every year as we approach a legislative session, I get asked more and more questions about, well, how does Minnesota do this? How does South Dakota do it? I'm not here to advocate that one state has a better system over the other, but I'm here to provide hopefully as much information as I can that I know about maybe some other thoughts and processes about how states handle some of these issues. And like I said, I'm going to try to focus as much as I can on issues that might come up for managers and their attorneys and their consultants in North Dakota water resource districts. I'm used to presenting in this format where I basically put up this slide. I talk about how the common property law issues really form the foundation for understanding everything else that builds off of that. So these are the judicial cases that started in the late 1800s, in the early 1900s, in the 1970s in North Dakota, where judges settled disputes between neighbors over the management of water. And that's important because it set up what rights, responsibilities, and obligations do landowners have when it comes to managing their water. and that is a property right. As attorneys, we talk about property comes like a bundle of sticks. There's a number of different rights associated to your property. One of them is your right as a higher landowner to do drainage reasonably, and your obligation as a lower in elevation landowner to receive that water. And understanding that is really important in order to legislate and create land use controls, in order to enforce them, in order to design and plan public water management projects, and also into understanding, what environmental regulations are proper and which of them go too far. So usually I put up this slide. I talk for about 5 or 10 minutes about how, as a firm, when we get approached by a landowner, a local government client, who's working on a water management project, these are the things that we think about, and these are the things we go through. And then I open it up for questions and try to focus my presentation on what it is the people in the audience actually want to talk about and know more. That's a little bit more challenging in this setting. So it's going to feel like I'm buzzing through my slides. They're there as a reference. They're there to go back to if you have questions later or want to go back and look at something after the presentation. But I do have my chat box open. If you have a question and you want to type it in there, or you want to just say, I have a question, we need to pause, I don't mind being interrupted. It's the style I prefer. If you want to stop at something and not wait until the end of that section, that's fine. I'll also try to stop for a few minutes at the end of these 4 sections and just make sure that anyone who didn't want to interrupt with a question gets a chance to ask that. So with that, we're going to start with that foundation, understanding the common property law rights between neighboring landowners. And I'm just going to start with talking about 4 situations where this comes up. Where do these disputes arise from? The first one is one that probably most people are familiar with. It's where an upstream landowner is doing drainage and the downstream landowner is being flooded or claims they're being flooded. What are the rights and responsibilities of the upstream and downstream landowner in that situation? Another situation where this comes up is where the downstream landowner has blocked the waterway, and that blocking of the waterway is flooding the upstream landowner. Another one is an upstream landowner is impounding the water that used to flow across the downstream landowner, or is diverting that water away from that downstream landowner, so they no longer have access to either all or a certain volume of water they're naturally accustomed to flowing across their property. So think about the downstream landowner who relied on a water course for a water source for cattle, and now that water's been diverted away from that pasture. And then finally, an upstream landowner directs water into a downstream landowner's artificial drainage system. If your downstream landowner invests in some water management infrastructure first, do you have the right later to come in and connect to that infrastructure? So these disputes are settled by what's called the reasonable use doctrine. It was adopted first between Minnesota and North Dakota by the Minnesota courts. And then the North Dakota courts, in the earliest cases that came up between neighbors arguing over water, they cited to the reasonable use rule in a bunch of states, but ultimately related back to the way that Minnesota described that rule. And so North Dakota adopted the same doctrine or the same method of resolving these disputes that the Minnesota courts had set in place. So between the 2 states, almost virtual similarity in the way that these disputes are settled when they end up in front of the judiciary. We'll talk later about how the legislature has maybe modified some of these processes. But anytime a drainage dispute ends up in front of the court, it's settled through applying that reasonable use doctrine. And then we'll just touch briefly on South Dakota has a very similar type law, but different. They've actually gone as a legislature and codified those reasonable use principles, modified them slightly. And so we'll just talk briefly about the difference there. And then here's my tip. And I say this in virtually all my presentations. The goal is try to avoid, whenever you can, paying your lawyers and engineers to argue in front of a judge about what client is more reasonable. because the same set of facts, the same attorneys, the same expert engineers, but different judges can easily come up with different opinions. This is not a cut and dry situation. There's always risk in letting a judge decide the rights and responsibilities between neighbors. So we try to look for ways as water attorneys to resolve these disputes without throwing it in front of a judge and taking that risk. So this is the very first case in Minnesota to articulate that as a state, Minnesota was going to follow this reasonable use rule. It's called Sheehan versus Flynn. It was adopted in 1894. So again, judge made law. This is before there were very many statutes in Minnesota that regulated or controlled or managed drainage. But Sheehan was the landowner who was downstream of Flynn. Their property was separated by a small 40-acre parcel. And Flynn wanted to drain a 20-acre depression on his property that ponded in the spring. It didn't stay wet year-round, but it did get pretty deep, 4 feet deep in the spring after snow melt and maybe before ground thaw, and after heavy rains. And sometimes that pond impacted a roadway adjacent to Flynn's property. And so Flynn, wanting to farm that land and probably also wanting to help his neighbors be able to use the roadway more year-round or more successfully than before, he dug a ditch on his own land and connected that 20-acre depression into a natural ravine that eventually carried that water across the intermediary 40-acre parcel and then across Sheehan's land and down past Sheehan's land into about a 30-acre lake. The lake had really high banks, so it was really steep banks leading into the lake, but there was a slough adjacent to that lake that was nearly level with the lake and that extended onto Sheehan's land and was typically wet, maybe except in extreme dry times. And that was the condition for about 5 years. That water stayed channelized in that ditch, draining from the Flynn parcel and across the Sheehan parcel and into the lake. And that was fine. Nobody really complained between 1876 until about 1893. Then the county came in and said, you know what? We need to clean out and reopen this ditch. We need to possibly improve it a little bit. And we need to make this ditch a more reliable way of draining the water that sometimes impacts our roadway to guarantee that that road is open year round. And the county came in, they condemned the ditch on Flynn's property. It sounds like he was pretty cooperative in the project, and they even hired him as the contractor to reopen and repair that ditch. That's when Sheehan got upset. He didn't want the county ditch coming through there and draining onto his property. So he filed a lawsuit. He asked the court to grant an injunction to close up that ditch. They had a bench trial in front of the judge, and the court found that when that ditch was open and reconstructed, that it raised the water level in the lake in the spring of the year higher than it was, and maybe that caused about 1 to 2 acres of damage on Sheehan's land. I think the court says the damage at that time was about $50. Remember, this was the late 1890s. But the court said, you know, without that ditch, that water would have accumulated on Flynn's land and not drained onto Sheehan's lake, and he wouldn't have lost those 1 or 2 acres. And so the trial court sided with the downstream landowner. But Flynn appealed. There was no contest of the facts. Flynn just said that he believed, based on those facts, that what he did didn't violate his property rights. And the Supreme Court of Minnesota agreed with him. They said that that ditch was necessary in order to drain the highway and drain Flynn's land. The Supreme Court said, you know, we're going to infer based on the facts here that there was really no other reasonable way that that depression on the upstream land could have been drained, and no other natural drain that the water could have been directed to cause less damage or to be a more reasonable route. And so they adopted this rule that a person must use their land to not unnecessarily or unreasonably injure their neighbor. And one of the circumstances to consider is the amount of benefit to the estate drained or improved compared to the amount of injury to the estate on which the burden surface water is cast. So one of the key facts for the court there was Flynn was gaining 20 acres of prime agricultural land. He was restoring the use of the highway. while the injury to the downstream landowner where the water naturally flowed anyways was perhaps a little bit longer ponding in that slough area of 1 or 2 acres each spring. So in that case, the court talked about a lot of the factors that they used to reach their ruling, but it wasn't until about 50 years later in Anderson versus Keelahan case, another Minnesota Supreme Court case, that the court really summed up the reasonable use rule into kind of this neat 4-factor rule. And here it is in that second bullet point. It says that a person in making a reasonable use of their property and acting in good faith can drain waters off of their land and cast them as a burden onto lower property, even if that carries waters that sometimes would not go that way, as long as they meet these 4 factors. Number 1, there's reasonable necessity for the drainage. Number 2, reasonable care is taken to avoid unnecessary injury to that downstream landowner. 3, the utility or the benefit to the person doing the draining outweighs the harm to the person receiving the drainage. And in our instance where a landowner has blocked drainage, sometimes that's not about the benefit to the person draining, but the benefit to the person who's modifying the drainage. And then finally, if we're practicable, the drainage is accomplished by improving and aiding the normal and natural system of drainage according to its reasonable carrying capacity, or if there's not a practicable natural drain, using reasonable and feasible artificial drainage. Then we go to fast forward to 1971. This is one of the first North Dakota cases I could find where there was a dispute between landowners. I believe this came out of Steele County, but essentially there was 2 lakes upstream that each were naturally drained downstream. The downstream landowners had improved and streamlined the drainage. Then the upstream landowners did the same. And at some point there was a dispute over whether the upstream landowners had maybe done more drainage than what the downstream landowners believed they were giving permission for. So a lawsuit ensued, and ultimately the court said at that time there was a permit that was required to drain lakes. And so that part of the case was settled on the fact that these landowners didn't have the permit to be draining water from those 2 lakes. But as to the rest of the system, the natural stream that was streamlined and the potholes that were drained along the way, the court said that at that time, that drainage did not fall into the state statute permitting rule. And so the court cited to the Anderson and the Sheehan cases from Minnesota and resolved that case, applying the reasonable use principles. So again, North Dakota applies same rules, same principles as Minnesota, those 4 factors to determine is that drainage reasonable or not reasonable. South Dakota, they kind of developed similar to North Dakota, similar to Minnesota, but on 2 different levels. Until about 1985, there's quite a few cases in South Dakota that created something similar to the same principles of reasonable use that Minnesota and North Dakota has. I would just say if you read those cases, one thing that is really striking in difference is that South Dakota puts a lot of emphasis on if you are the upstream landowner, your obligation is to make sure that you're draining across and not onto the downstream landowner. Where in that first case I cited in Minnesota, the courts had said, moving water out of 20 acres to lose 2 acres downstream, that's shifting a burden upstream to downstream and letting it sit there, that was reasonable. That might not have been true in South Dakota. The courts there really focused on saying you can't just move your burden from your land onto my land. You need to make sure that that water drains across the downstream property. And they did have some aspects of legislatively controlled drainage similar to our North Dakota legal drains in the early 1900s in South Dakota, but by and far almost all neighbor-to-neighbor drainage disputes were resolved by the judiciary. So in 1985, the legislature in South Dakota rewrote their entire drainage code, and they placed all control, potentially, if the county wanted it, with the County Board of Commissioners. So what they did in South Dakota was adopted 46A-10A-20, and that's here on this slide. And if you read through these, they're slightly different, but very similar to those reasonable use principles. So the legislature basically codified those reasonable use cases in South Dakota and said, we're going to allow counties to have a bigger hand in drainage management if they want it, but we're going to set a floor and say that in doing so, whether it's constructing your legal drains paid for by assessment district or enacting some ordinances or controls, you cannot exceed these reasonable use guidelines. And if you do, then it's a violation of statute, and that project either has to be abandoned or remedied, or the ordinance is perhaps declared illegal because it violates that 46A-10A-20. And then in 1988, again, because all of these drainage principles are tied to a property right that landowners own, and anytime the legislature starts regulating or managing property rights, there's always a constitutional question of whether that management has gone too far and has infringed on that property right, which is a really hard analysis sometimes to answer. But the legislature in South Dakota, to help counties navigate that, in 1988 created a recording system that said, natural drainage is automatically vested without recording, but certain modifications to natural drainage and completely artificial drains that are registered within 7 years of July 1st, 1985 would be vested, meaning that would be a property right that cannot be taken away. There was a process where you would register your drains. Notice would be given to adjacent landowners. They could dispute it, and only those registrations that were not disputed or were not resolved favorably to the registrant are vested. So a little bit unique process there. Any questions on basic property common law rights before we move on to talking about drainage easements?
Kale, this is Lance. I have a question that was sent to me, was specific to North Dakota. Would diverting water away from a downstream landowner in North Dakota be a drainage issue or a water appropriation issue?
So very good question. We're going to talk a little bit here coming up on land use controls. And North Dakota has adopted a set of statutes that govern the appropriation of water. And North Dakota has some diversion of surface water or impoundment of surface water statutes that require you to get an appropriation permit from the state engineer. So these cases in North Dakota were early drainage cases. The ones that I found don't talk about that diversion of water. And I'm not aware of any case in North Dakota. It might be out there, but that's prior to the statutes on appropriating water. I think they've been around for a long time, and I think that almost all the history in North Dakota would have dealt with that through an appropriation permit.
And in North Dakota, might we have a difference in one part of our state compared to another, where potentially in the Red River Valley or somewhat close, you might want to be actively trying to remove water for agriculture purposes, and then the western part of the state, you're trying to figure out how to save water for livestock or the like?
Right. So in the United States, the cases in the law talk about surface water rights as being either eastern or western. Eastern being referred to as a reasonable use. And again, state by state, the exact principles might vary a little bit. But in the western United States, that's surface water law there, the body of law is referred to as prior appropriation. It was more about who was there first in time, where landowners lived a lot farther away from the water resources that they wanted, than it is about reasonable use and managing that between different landowners. I've heard different opinions on whether North Dakota is a reasonable use or a prior appropriation state. I think the type of drainage and water management I'm talking about in this presentation, my opinion is the whole state would follow the reasonable use principles, if it came down to a situation that would have to be resolved by the judiciary and wouldn't be managed by statute. But I think there's this great website at the Oklahoma State University on this topic and this law that actually characterizes most of the Great Plains states, including North Dakota, as a hybrid. They say that the judiciary resolution would be reasonable use, but that the state has adopted some prior appropriation type laws into statute. And so it's really fact specific about the issue you're dealing with as to which one applies. And I just got a question in the chat. I'll take this one and then I'm going to keep moving to make sure we get through everything. But someone asked if a township enhanced a natural waterway to help a road and a dispute came up and downstream landowners closed the drainage, would that be reasonable use, or do the downstream landowners have the right to stop the water? Okay, so very good question. And again, this one would be resolved potentially through statute and through the judiciary. So first, with the township enhancing a natural waterway to help a roadway, and a dispute came up and downstream landowners closed the drainage. The township has kind of two things that are governing its management of water crossing that township road. One is reasonable use. Just because they're the township does not mean that they don't potentially have to follow the reasonable use principles in how they manage that water. The difference being if it's a township and they exceed the reasonable use in the management of their water, and that causes a permanent flooding downstream, that's called a taking. And the downstream landowner has a cause of action for inverse condemnation or to force a court to start eminent domain proceedings to be compensated for the damages to their property that are caused by that amount of water that exceeds that reasonable use. The other thing townships have to keep in mind as a road authority is the crossings that they put in place to accommodate that waterway. The state engineer has developed with the North Dakota Department of Transportation a set of guidelines that are called stream crossing standards. And they measure what the minimum size culvert needs to be in order to accommodate a watershed that reaches a crossing in a roadway. And if those standards are followed, the township will not be held liable. If those standards are not followed and that impounds water upstream, the township or whoever the applicable road authority is could be liable for the damages that are caused by that impoundment. And then for the downstream landowners who then close the stream, if the portion that they blocked is the portion that's now back to what the natural waterway is, that could be resolved judicially through reasonable use. But also there's an administrative process where a complaint can be filed with the county water resource district for an obstruction to that natural waterway. Natural waterways and drains that are obstructed, complaint is filed with the Water Resource Board. It's investigated. If they find that there is an obstruction there, then they notify the landowner and direct them to remove it. If they don't, the Water Resource District has authority to have the obstruction removed, restore the natural drainage, and then assess the landowner the costs of doing that. And then of course there's an appeals process that goes with that as well. Okay, and then there's a question, one more I'll take. Is it fair to say common use doctrine determinations relate to drainage and volume and does not address water quality impacts? Absolutely. Reasonable use is about the management of the rate and volume of water. It is not about water quality. Water quality is governed legislatively and through administrative law, and we're going to talk about some of those in the environmental regulations section. Okay, so real briefly, you know, a landowner, a local government planning a public water project comes to me and says, we're going to be interfering with water here, water flow. What do we have to worry about? And clearly there, like I said, there are things you can do as a landowner who's higher in elevation that are reasonable and don't require permission from the landowner downstream. But as the downstream landowner, there are certain limitations, and you have property rights as well that are protected that limit the reasonableness or unreasonableness of that drainage upstream. But like I said, that's a risky proposition to go into, because judges can look at all of the facts that are involved in making that determination differently. So the way that we try to minimize that risk is through either cooperatively negotiating drainage agreements and easements, or if you're a water resource district and it's a publicly managed project, you do have condemnation power if you can't negotiate it cooperatively to take drainage easements or flowage easements that you need to accommodate a lawfully adopted project. And so here's just some tips on drainage agreements. One thing to keep in mind is that drainage agreements should have a right of entry, so that you have the right to go onto the property to inspect and maintain and repair the drainage across that burdened land. Easements can be either, or contracts, excuse me, easements are just contracts. And contracts can either be expressly stated in words, or they can be applied by people's conduct. Contracts can also be oral. They don't have to be in writing to be an enforceable contract, except in some situations. So most states have a statute of frauds, and that lays out the agreements that must be in writing in order to be enforced. And one of them in almost every state is an agreement that manages an interest in property has to be in writing. So most drainage or water easements to be enforced need to be in writing. Now there's a couple exceptions to that. One of them is an easement by prescription. If you're familiar with adverse possession, the manner in which property that you don't own, at least in title, is acquired because of your use and the manner of your use of that property, the same can be true for drainage and water. Drainage that is adverse is continuous and uninterrupted and is for the period of prescription, which in North Dakota is 20 years, can create a flowage easement across property downstream. So at that level that the drainage exceeds reasonableness and moves into unreasonable, if it's been going on for 20 years without permission from the downstream landowner and it's continuous and there's no interruption in that 20-year period, a court might declare that you now have an easement by prescription to keep using that drainage. There's also easements by implication. There might be a North Dakota court case on this. I wasn't able to find one. There are several Minnesota court cases on this, and they basically talk about situations. Most easements by implication are about roadways where land was owned by one common person and then divided, but it's clear that there needed to be a roadway reserved across the one property in order to gain access to the other property. The same can be true for drainage. It's maybe a pretty particular fact situation, but it's a type of common law easement that judges have created and is out there as an exception to the statute of frauds. And then just keep in mind that easements can be terminated through merger. That's where the one landowner acquires the land upstream and downstream, and now it's a common landowner. There's no split. That terminates an easement. There can be an express release of an easement. Easements can be abandoned through conduct and ceasing to use the easement. And then in North Dakota, we have this statutory 99-year limit that applies to all easements, except, this is going to disappoint a lot of people, and this is a question I get at least every other week. That 99-year limit does not apply to U.S. Fish and Wildlife Service easements. When the legislature adopted that statute, it sparked litigation between the state of North Dakota and the U.S. Fish and Wildlife Service that went all the way to the United States Supreme Court, and became an important case in how we address those easements. But unfortunately, the Supreme Court ruled that, not that that statute was unconstitutional, which is why it's still on the books, but that that statute, because it was adopted after that program started, could not bind and tie the federal government's acquisition of waterfowl production area easements. So even the new easements that are being acquired today after that statute was adopted, they are not bound by that 99-year limit per United States Supreme Court precedents. And then a couple other things that go with this. Downstream maintenance. A really common question I get is the landowner downstream of me is not maintaining an artificial ditch, or they're not maintaining a natural water course. That accumulated sediment and vegetation is blocking water and causing it to back up onto my property. They're flooding me out. Aren't they liable for that? And the answer to that in almost all the reasonable use states is no, including North Dakota. And there's a case, Buchholz versus Barnes County Water Resource District from 2008, which lays that out very clearly, that there's no statute or no common law, no judge-made case that obligates a landowner downstream to maintain that free flow. That has to be accomplished through voluntary cooperation or through a drainage agreement, a contract that obligates that landowner to do maintenance. And then that question, after I answer, is usually followed up with, so may I go onto my neighbor's property and maintain that water course or drain over their objection? No, that's not possible. Permission is needed from your neighbor. When you send water onto someone's property, the water is only a trespass if it's unreasonable. But when you physically set foot on their property or you bring equipment onto their property, your presence there is a trespass. And so even if you're accomplishing something to benefit your own property, you being on that property in person is a trespass, subject to potential civil litigation or even criminal prosecution. However, water resource districts, in one of their many broad powers, they do have the power in their discretion. They're not obligated to do this, but they do have the power to do repairs and cleanouts of natural water courses. And the water resource districts need to acquire the access rights to do that. They try to do that obviously cooperatively at first, but remember they do have condemnation power to acquire that access for a duly authorized project, as long as just compensation is paid for that easement and for any damages that are caused in completing that repair and that cleanup. Of course, I think for a lot of water resource districts, the issue there is budget. How do you make the decisions of which water courses to clean out? When you do one, are you going to get 10 more requests? And obviously, water resource districts are dealing with limited budgets. And then finally, this is again a Minnesota case, but it kind of relates to this concept of downstream obligations and maintenance. My theory is that I think the same argument could apply in North Dakota, since this comes out of the same body of reasonable use as the court cases that North Dakota cited to when it decided what rule it was going to follow. And this case is about neighboring landowners who got together. This is very common, especially in Minnesota, on a handshake deal. I'll contribute 20% if you contribute the other 80%. Or you pay for the pipe and I'll provide the equipment. But essentially neighbors get together and they cooperate in labor and in cost to dig a common drainage system that benefits their property, but they put nothing in writing. There's no signed easement agreement. What happens when that downstream ditch or pipe now fails and the upstream landowner is being flooded out? Well, without that written agreement, if the downstream landowner now objects, you don't have the right to go in and clean that out, even though that you cooperated and worked together and installed it. But if the downstream neighbor affirmatively does something to block that artificial drainage improvement, this Will v. Bowler case says that that's patently unreasonable. That once neighbors get together and cooperate in the management of their water, neither neighbor can do something to deprive the other of the benefit of that management. They're entitled to rely on that cooperation. So any questions about drainage easements before we move into talking about some land use controls?
Kale, I have one question. You mentioned that it would be trespass to go downstream to restore property, or for water resource districts need permission. Is there a difference if it's a sovereign or state-owned waterway or navigable, in fact, at statehood? Or is it still considered the neighbor's property if it's the James River or the Cheyenne River, for example?
No, if it's a sovereign waterway where the state owns the bed of the water, then that's no longer private property. That is sovereign property owned by the state, and the legislature has tasked the management of that primarily with the state engineer. But to get to that area and to do that work, number one, if it's going to impact state sovereign water, you need likely a permit and a permission from the state engineer. But number two, if you have to cross private property to get there, you still might need an easement access in order to do that. And then someone sent me the Supreme Court ruling on the flowage easement from the Nagel versus Emmons County case. And I think I meant to include that in there. Yeah, it's this bullet point here, the principles for the easement by prescription. So this is for the comment in the chat here is that this is for a flowage easement where water had been for 20 years or more adverse to the landowner, flowing continuously and uninterrupted. And the courts had claimed that they had acquired an easement to do that. Okay, moving on to land use controls. So I'm going to go briefly through North Dakota. There are a lot of land use controls in North Dakota. The only ones that I'm focusing on for this presentation are what's referred to as our surface and our subsurface drain statutes. And to me, this sometimes is a little bit of a misnomer when we talk about surface drains. Well, when we say surface drains and subsurface drains, to me, that's the right way to refer to it. When we start saying surface water and subsurface water, to me, it might get a little bit confusing and might be a little bit of a misnomer to refer to the water as surface or subsurface. And the reason why is because the courts, they categorize water primarily as natural water courses, surface water, and groundwater. And it's common in court cases to find the courts say, snow, rainfall does not lose its character. And what they mean is does not lose its treatment by the courts when it percolates down into the soil. It is still considered surface water. It just is now located at the moment below the surface. But legislatures certainly have the authority, subject to that potential constitutional issue of going too far in regulating the management of water as a property right, to regulate surface water through land use controls. They can either do that like they did in South Dakota through delegating that authority to county boards. They can do it like they've done in Minnesota by delegating that authority to watershed districts. We'll talk about those in a little bit. Or in North Dakota, the primary two I'm going to talk about are legislative created permit requirements. So the first one that I'm going to talk about is 61-32-03. That's the citation today. It requires a permit for any person before draining a pond, slough, lake, or sheet water, or any series thereof, which has a watershed area comprising 80 acres or more to first get a permit. That permit is submitted to the state engineer. The state engineer refers that to the water resource district where a majority of the watershed is located. The state engineer might require that any drainage that's considered statewide or inter-district significance be returned to the state engineer for final approval. And it says a permit may not be granted until an investigation discloses that the quantity of water which will be drained will not flood or adversely affect downstream lands. In 2008, the state engineer at the time requested an opinion from the North Dakota Attorney General on whether tile drainage or subsurface drainage systems, so again, talking about the structure, not the location of the water, but the structure that manages the water, whether those systems require a drain permit under 61-32-03. And the Attorney General opined that draining is unambiguous, that word in statute's unambiguous, and it includes any method of removal of the surface water. He said it would contravene the plain language and purpose of that statute if it was determined that it applied only to surface drainage techniques, and subsurface drainage techniques were allowed to be used without consideration of potential adverse effects to downstream property owners as required by this statute. So In North Dakota, Attorney General opinions are supposed to be followed by local governments until the Attorney General advises otherwise, or the legislature or some court changes the impact of that ruling. And so as of 2008, tile systems that met this threshold of draining a pond, slough, lake, or sheet water, which had a watershed of 80 acres or more, required a permit under the same procedures that existed at that time for what is still the process for what we call, surface ditches or open channel surface ditches. So that was 2008. In 2011, then the legislature created a separate section for permitting tile systems. They called that 61-32-03.1. And they made some key changes in this statute from the existing surface drain statute. First, they said installation of a drain tile system covering 80 acres of land area or more. So that changed from watershed to land area, requires a permit from the local water resource district. Applications that were determined by the local water resource district to be of statewide significance were forwarded to the state engineer for consideration and approval. So that was being made at the local level first, and if determined to be statewide significance, then forward on to the state engineer for processing. Applications that were not of statewide significance were then evaluated by the local water resource board, and permit applicants had the burden to provide 30-day notice to downstream property owners within 1 mile of the proposed drainage. However, if the proposed drainage discharged into an assessment drain, a natural water course, a pond, a slough, or a lake, the water resource district may not require the applicant to obtain permission or a flowage easement once the water discharged into those features. So in some of the cases in North Dakota that talk about water management and talk about these permitting statutes, they make a point to reference, that the legislature and the way they set these up, you can see there's some mirroring of following those reasonable use expectations. So if your system is outletting into a natural water course, a pond, a slough, or a lake, it's likely, I'm not saying it's guaranteed, but it's likely that you're following the natural water course, which is one of the principles that is expected under the reasonable use rule. So the court cases often talk about how the legislature has incorporated these reasonable principles into these land use controls. And there's even a case in North Dakota that says on surface drains, it's pertaining to 61-32-03, a landowner who was noticed in that permitting procedure, but either was not successful in getting the permit denied or did not appeal that permit, was later barred from bringing a reasonable use claim because the court said that reasonableness existed in statute and was settled through that permitting process. And then continuing with that in 2011 statute, if an investigation by the local water resource district or downstream landowner within 1 mile demonstrated that the proposed system will flood or adversely affect downstream lands, then the water resource district may require them to obtain a flowage easement, again with that caveat that cannot be required once the system reaches or discharges into one of these features. And then in 2012, there was an Attorney General opinion on water resource district authority to assess costs for some of its administrative processes to landowners and to people who filed complaints. And the request was about a statute that wasn't about tile permitting, but in the opinion, the Attorney General pointed out to the language that was used in the tile permitting statute and said that the legislature, without providing express authority to assess costs for the investigation into that downstream impact, was not giving the water resource district any authority to assess those costs to the landowners that were involved. And that opinion talks about, the language that the legislature needed to use to expressly require that. Concurrent with that 2011 carve-out statute, the Senate and the House of North Dakota adopted this concurrent resolution that talks about the benefits of drain tile and the desire to promote drain tile to alleviate downstream flooding and providing additional storage and to reduce salinity of the soil. That's concurrent resolution number 4019, adopted in 2011. I started practicing law in 2012. I think I started practicing in North Dakota soon thereafter, probably in 2013. And these were some of the questions that I would get from water resource districts, from landowners, and some of the issues that would come up as county to county that permitting statute tried to be implemented. One of them was, how are the 80 acres of land area calculated? How do you handle systems that have multiple outlets? Maybe the whole quarter is pattern tiled and one half of it outlets to the south and one half of it outlets to the east. Is that one system or two systems? What level of evidence is needed to trigger the requirement of a flowage easement? How long can it take to process a permit application and make a decision? What's the process for reviewing and making decisions on applications that constitute statewide significance? And one that I thought was always kind of unique was, what if a downstream landowner does not object to my project, but they're unwilling to record a flowage easement against their title? They just don't want that on their title of record, which, you know, really is more about a relationship between neighboring landowners than the permitting process itself. But I saw this situation arise a couple of times where the water resource district found that a flowage easement was needed, and the landowner who needed to provide it said, look, you know, I don't put your tile system in. I absolutely don't care. I don't think it's going to harm me. I just don't want to have a permanent easement recorded across my property. And so that was a situation, you know, we didn't quite know how to deal with. So in 2017, there was an amendment to that statute. I think its goal was to try to fix some of those issues. Whether that was accomplished or not is probably debatable. But it changed some of the language and definitely expanded the length of the statute in trying to accomplish that. So some of the changes that came out of that we saw were installation of a subsurface water management system comprising 80 acres of land area or more, so that stayed the same, requires a permit, but expressly said that the watershed area drained may not be used to determine whether the system requires a permit under this section. And I think that was meant to emphasize that point originally out of 2011, that we're no longer looking at the watershed draining to the system. We're looking at what's the actual land area of acreage that's being used. And the term footprint was used in committee hearings. The statute directed the state engineer to prepare a permit application, and then the state engineer and some of its guidance that can be found on that permit application use that language footprint, and listed out here, like I have on the slides, some guidance onto how that 80 acres is calculated. This works well for a pattern tile system. It essentially says, look at the zone of influence, which is the acreage from which the system will remove subsurface water, and is calculated by adding 1/2 of the tile spacing to each exterior dimension of the system, which, you know, can be calculated pretty easily and pretty objectively for a pattern tile system. Then we have another administrative process in North Dakota. It's how to deal with drains, whether they're surface or tile systems that get installed that don't follow the permitting requirements. In North Dakota, if you're a landowner who's being flooded or experiencing adverse impacts from an authorized drain that was constructed before January 1, 1975, you can file a complaint with the Water Resource Board. Any person can file a complaint about an unauthorized drain that was constructed after July 1st, 1975, meaning you don't have to be a landowner experiencing flooding or adverse effects. My opinion is, from the best I can tell on my research, there's no statute of limitations on that permitting requirement. Meaning if it required a permit at the time, you might have exceeded the 20 years and acquired all the flowage easements you needed, but you might not have a permit. And the statute would say that even if you have that prescriptive flowage easement, you might still need that permit in order to keep that drain open and maintained. This gets to be a little bit confusing and a little bit hard to enforce in determining what constitutes a non-complying drain for a couple of reasons. First of all, drains that were constructed before July 1st, 1957 do not require a permit. That's before the permitting statute in North Dakota was in force. drains that were constructed between that time period and July 1st of 1975 did not require a permit if a county drain board did not exist when the drain was constructed, or if the construction was supervised by state or federal agency, or the drain was constructed pursuant to Chapter 6121. That's our legal drain chapter. So some key points to remember are: apply the statute that was in force at the time the drain was constructed. One of the things that may be still unsettled by precedents, but that I've argued, is the term sheet water was not added to the drain permit statute until 1997. And I know there's people on the call who might disagree with me on this, but my opinion is before 1997, you need to show that the drain drained a pond, a slough, or a lake with a watershed of 80 acres or more draining to it in order for that drain to require a permit. Sheet water was added in 1997, and I think there's universal, non-disagreement that now what you do is look at the outlet of that drain and calculate the watershed draining to it for surface drains to determine if that drain required a permit. And then there's also in the statute a reference to that you also might have to look at the local water resource district rules. There might be multiple across the state. The only one that I've encountered in my practice is that the Stutzman County Water Resource District did adopt a rule. I can't remember off the top of my head what year it was, but it mirrored the state statute on surface drains, except that it changed that 80 acres, I believe, to 40 acres. And so they had a little bit more stringent rule in Stutzman County that was adopted locally. I pause there for questions, but I think that I'm going to get through just real briefly kind of some of the differences in Minnesota and South Dakota first. So again, North Dakota, there's two main statutes that apply to, we call them surface ditches, subsurface drains. The difference in Minnesota and South Dakota, and I get probably questions the most about Minnesota, is the Minnesota legislature delegated that authority to watershed districts for local land use controls. Primarily, there's quite a few environmental regulations in Minnesota, but when it comes to land use controls, like the ones that we're talking about with surface ditches and drain tile systems, that's primarily been delegated to the watershed districts. So the Watershed District Act was adopted in 1955. Watershed districts in Minnesota are governed by a board that's 3 to 9 managers that are appointed by the county commissioners of the counties that have land in that watershed, typically in proportion to the amount of land, which is directly proportional typically to the tax base or the contribution in land taxes to operating that watershed district. In the Minnesota, watershed districts develop water management plans. They update them every so many years. And then they have the authority to adopt and enforce rules in order to implement those plans. And those rules are where you see the land use controls for the land in those watershed districts that apply to your surface drains and your subsurface drains. In South Dakota, again in 1985, when the legislature redid its entire drainage code, they put a lot of authority with the County Board of Commissioners, and they said that counties in South Dakota may adopt, it's not required, but may adopt official controls such as ordinances, orders, regulations, maps, or procedures that regulate to drainage. So the type of land use control or the procedure might change county to county, but in every county, those official controls must not violate those reasonable use drainage guidelines that the courts created through case law that are in Statute 46A 10A-20. And there are several counties in South Dakota that have adopted permitting processes for tile systems that have had their ordinances challenged and either a judgment issued by the court overturning the ordinance for violating those principles, or the board voluntarily through that litigation either totally rescinded or revised their permitting ordinance, probably after realizing that either it wasn't worth the cost of litigation or that they likely weren't going to be able to succeed in convincing a judge that they follow those principles. Probably the number one issue that I've seen in South Dakota with ordinances is several counties try to basically say, you can have your drainage system in our county, but in every circumstance, you need to get permission from the downstream landowner. The problem with that being, if the drainage system meets those reasonable use principles and you give veto authority to a downstream landowner who can, say no for any reason, you're basically giving the downstream landowner the ability potentially to deprive that upstream landowner of that reasonable use drainage right. So a little bit more on South Dakota general powers. I won't read all of these, they're pretty broad. A lot of watershed districts have an operating budget that comes from levying a tax on the land in the watershed district that allows them to hire full-time staff, full-time consultants, engineers, attorneys. Again, they're required to put in place water management plans for their watershed district, and they have the authority to adopt rules to enforce them. So a common rule that you see in Minnesota is, when it comes to subsurface water management systems, is a design standard, saying that if your system meets these criteria, one of them potentially being a limitation on the drainage coefficient, then you're entitled to a permit. And the downstream consideration between landowners may be either left to the judiciary, or may be managed just through implementing some reasonable design criteria on those drainage permits. So again, not here to advocate for one way or the other. I think the people that I've heard that say they like the design criteria is it's a little bit easier to administer administratively. So you might have a watershed district with an engineer who's an administrator who can get a permit application for a system, and the board might or might not, varies watershed district to watershed district, but some watershed districts will delegate some authority to that engineer to say, if it meets our design criteria, you can sign off on it, and it gets handled pretty efficiently and administratively. So I'll stop there and see if there's any questions about land use controls.
It looks like, okay, you see the question?
Yep, to your point, I guess everyone can see it, but I'll just read it. To your point on sheet water, could it not be interpreted that its addition to the North Dakota Century Code was intended as a clarification of a reasonably understood implied situation by interpretations and actions by the North Dakota State Engineer and water resource districts prior to that? I guess I'll start by saying I think there's probably not universal agreement on the answer to that. My opinion is that some water resource districts were reading that sheet water application into the statute and some were not. I probably need to go back and read it more clearly, but I know at one point I pulled the legislative history I could find on the addition of that in 1997. And I believe that that point was talked about, that there wasn't universal application of the way in which that was being applied. And I'm not aware of a court case where a judge has set any precedents saying, whether or not that point about the application of sheet water only starting in 1997 is true or not. So if someone on the call knows of that case, probably be beneficial to share that with the group. But good question.
Kale, I want to let the folks know we have a handful of people who are only on by telephone, so would not have the ability to text or send a chat message that they have a question. So at the conclusion of your presentation, we'll open up those lines. So those of you who are joined by telephone, if you'd like to jot down your question, and we'll open up your lines shortly.
Great. And Lance, do you have any that were sent to you privately before we move on?
I do not.
Okay. Okay, next I'm going to go into now the third point of my presentation, which is public water management. And again, there are multiple in North Dakota, multiple in Minnesota, multiple in South Dakota, ways in which public units of government manage water, do flood control, handle projects. The one that I'm going to focus on is, because I was asked specifically to focus on it, is legal drains and assessment districts. And in part because I'm going to touch on a comparison primarily between North Dakota and Minnesota on a couple of points that I was asked to present about. So again, I'm not saying that these are the only types of ways public water is managed, but these are the two I'm going to focus on in this presentation. And Dennis Reap, I know you're on the call. This is these slides are a presentation Dennis and I gave to some landowners in Renville County, and then also some slides I gave to landowners in Foster County, to water boards that I work with and Dennis works with, Renville County, who were wondering, how this process works. Two counties that don't yet have any legal drains and wanted to know, whether it was right for their county and they should start that process. So a lot of these, again, the slides are reference material so that landowners could go back and see what's in statute. I'm going to basically do a very high level overview of just the process for a legal drain. Before I start that, I should go back and say in North Dakota, we still have 2 chapters that provide the process for establishing legal drains. They are not exactly identical, but they are very similar. And in substance, they're identical. Just some procedural differences between the two. But one of them, 61-16.1, this is a process where the Water Resource District Board will on their own initiate a legal drain in an assessment district. And in 61-21 is the process for a landowner or a group of landowners, that want to petition the Water Resource District to start that process. So when it's the landowners, it starts with a petition for a new legal drain that has to be signed by at least 6 property owners or a majority of landowners within the proposed district. So you can have very small legal drain assessment districts if you don't have 6 landowners in there, but a majority of the landowners is something less than 6. That's sufficient as well. But it is an or. You can have 6 landowners or a majority of landowners. There is a statute that references laterals, a petition process for constructing laterals. That statute says that you follow the exact same process as creating a new legal drain, except that the petition only needs to be signed by 1 landowner. That's the difference. The petition may require a bond. That's a decision made by the board. But the point of the bond is to cover all expenses of the surveys and the legal and the administrative costs that are accrued in developing the legal drain project if ultimately the legal drain is not established or a contract's not awarded to construct that legal drain. If no bond is required, my opinion is you can still go after the petitioners for those costs. It's just not secured by that bond. Or I wouldn't be one to say there's no authority for the Water Resource District to cover those costs out of its general fund. Certainly, if you're doing this out of 61-16.1, you can also use general fund money to cover those costs. But once a petition is filed, the first thing is that the Water Resource Board is supposed to examine the proposed drain and determine if further proceedings are warranted. And here's a statutory grant of property access to do that. The board or its employees may enter upon any land traversed by any proposed drain or any other land necessary in order to gain access thereto for this purpose. So you have to obviously do it in a reasonable manner, but you have the right to go on property once a petition is filed in order to develop and work on your survey. Then really the meat of that first part of the process is the engineer developing a profile, a plan, and specifications of the proposed drain, estimate the cost of that project, and then also develop a map of the lands that are to be drained, showing what the regular subdivision of those lands are. The board does have discretion to modify the lines that are on the petition. They're not bound by the path that the petitioners petitioned for. But it's good, probably practice tip, when engineers and their attorneys and boards are at this phase to solicit landowner input and to provide early drafts of engineers report and help local landowners who are ultimately going to be voting on the project and tax for the project provide that input. And again, the estimate of the cost needs to be in sufficient detail in order for the board to determine what the probable share of the total cost is that are going to be assessed against all of the affected landowners within the drainage district. The board and its attorney and engineer, with assistance probably of the local tax office or auditor, is going to develop a roster of affected landowners. This typically looks like a spreadsheet that shows all of the parcels that are in the proposed assessment district and lists out how many acres are proposed to be assessed. If there's a classification for the property, what percentage is going to be assessed at, and ultimately what the total dollar amount estimated is for that property's share of the total project costs. And then the board, once that engineering report is approved, once the proposed assessment list or roster of affected landowners is approved, sets a time that's not less than at least 10 days after the hearing that votes on the project will be due, and then sets a time for a hearing in order to have a formal hearing notice to all affected landowners on the project, about the proposed assessment, and the vote. In North Dakota, and this is kind of a very unique process in North Dakota, landowners have the power to vote to tax themselves for the project, and that's a weighted vote. One vote for every dollar of assessment that's proposed for your land. This is the statute that just says the basis for what lands can be benefited, and water resource districts have the authority to include on that assessment list any county, township, or city that may be benefited, and then any lot, piece, or parcel of land which is directly benefited by such improvement. The federal government, this comes up often on U.S. Fish and Wildlife Service lands. Although this statute doesn't exclude them, there is a federal act of Congress that prohibits special assessments against federal agencies or governments unless the Congress has created a special and guaranteed fund to pay those assessments, which, guess what, rarely ever happens. So if you have in your assessment district federal property or Fish and Wildlife Service lands, not easements, but actual property owned by the Fish and Wildlife Service, that is exempt from special assessment. It's not collectible. Oh, and excuse me, this is called out expressly in North Dakota. Minnesota's where it's not expressly called out, but even without this statute, you would not be able to assess the United States for a special assessment benefit. Notice is given of the public hearing on the petition. And again, there must be at least 10 days notice under the landowner statute. I believe in a recent legislative session that was expanded to more than 10 days, maybe 30 days for board initiated processes. So again, in substance, a hearing is required, which triggers the timeline for voting on the project. But how much time and notice you have to give varies between the board initiated and the landowner initiated legal drain processes. But once that both ballots are filed, the deadline passes for the vote. Everyone has filed their votes who chose to file. Then there's a tallying of those votes, and the requirement is that 50% or more of the votes filed need to be in favor of the drain for the project to proceed, meaning that not voting is a true abstention. So if one person votes and they vote for the project, that's maybe not a great situation, but legally that project goes forward. So it's 50% or more of the votes filed that need to be in favor of the project for it to proceed. Excuse me, more than 50%. If exactly 50% vote in favor of the project fails. So it has to be something over that 50% mark. If the project fails the vote, then the district adopts an order denying the establishment of that drain, and that ends the project. It does not go forward. It would need a new petition to start that project over again. If the more than 50% of the votes filed are in favor of the project, then the board adopts an order establishing the drain. We don't yet rush to construction, but that's kind of a breaking point that if you can't pass that landowner vote, you don't proceed. That order needs to be published in the paper, and then that starts an appeals period that landowners have to challenge that order in district court if they want to have judicial review of that order and try to have the project order overturned. Then there is a notice of an assessment hearing. So again, we've been operating up to this point on a proposed assessment list. There's a second hearing after the landowner vote where the board takes comments on the percentage assessments that were provided and subject to review, and the board can adjust those up or down. But of course, any adjustment to those proposed assessments results in some of that burden or that cost being shifted to other landowners. That is allowed and called out in North Dakota statute. The board then adopts that final assessment list and then records that in its drain records and in the drain records of the county auditor. So again, here's a quick summary, the 7 steps procedurally that the water board needs to complete on a legal drain process. There are some engineering considerations. Obviously, engineers probably play one of the biggest roles in this process. The preliminary engineering report has to describe where the drain starts, its course, where the drain ends. That becomes the basis for the extent of the legal drain. The engineer also helps define the watershed, the drainage boundary, and potentially helps define what the benefited area is within that area as well. And the engineer helps provide some input on exactly how you apportion that assessment. It's not uncommon that lands that are closest to the drain are assessed at a higher percentage. There is, as many of you probably already know, State Water Commission cost share that is generally available for legal drain projects. There's a policy in place that you need to follow in order to be eligible. One of those requirements is to go through an engineering selection process. Another requirement is to do an economic analysis for drains that are over a certain cost threshold, and obviously to achieve that positive landowner vote. And I'll just mention that that economic analysis doesn't dictate whether or not you get cost share, but it does dictate the amount of cost share that you're eligible for. And then I'm not going to go over this in detail here because that's going to be in our last section here coming up, but the engineer then also works with the board and with the attorney to consider various environmental regulations and permitting requirements. A surface drain permit for legal drains that are surface ditches is needed from the state engineer. You need to be concerned about Section 404 Clean Water Act compliance and also following the water quality standards that we'll talk about in a little bit. If the location of the drain is going to cross any land owned by the Fish and Wildlife Service or burdened by a waterfowl production area easement, there's special considerations that are needed there. And then of course there's USDA NRCS kind of plays a unique role. And I think exactly the extent of their involvement is probably debatable between attorneys. There might be some differing opinions there. Mine is that the NRCS doesn't have the authority to stop a legal drain project, but they do manage some things that impact the value of landowners' property and their ability to farm their property in compliance with the program that could potentially be considered a damage to that landowner caused by a project. So we'll go over some of those in a little bit. Real briefly, some of the key differences in Minnesota, and these were the ones I was asked to touch on. In Minnesota, legal drains are called public drainage systems, but it's the same concept. They are created by a local government unit, which is either a county, a joint county board, or a watershed district, who becomes the drainage authority and plays a very active role in managing that legal drain or that public drainage system, much like North Dakota. These all start with petitions. There is not authority for a new public drain to be started by the local unit of government in Minnesota. One major difference is that the right-of-way acquisition or the eminent domain process is built into the statutory process in Minnesota. So when they adopt their final establishment order, they have acquired the right-of-way needed to build that project. There's no separate acquisition of right-of-way that's needed. There's no drafting of easements. There's almost always no recording of anything at the county recorder's office. It's a statutory right-of-way specific to public drains that's created and acquired through that process. And because of that, Minnesota probably in statute has much more procedural safeguards in place in the process and in the way that they go through establishing a legal drain or a public drain than North Dakota. And those are there because of constitutional issues with acquiring that property right as the local government board goes through that establishment process. There's a very specific standard of decision they need to make findings on in order to establish that project. The one I've been asked to comment on is at the bottom here. It's the third from the bottom, and it says, the drainage authority shall establish by order a proposed drainage project if. They need to find all of these things, but one of them is they need to make a specific finding that the estimated benefits are greater than the total estimated costs of the project, including damages. In North Dakota statute, the statute also requires that the benefits of a project need to be greater than the costs. But the big difference I see between the two states is in North Dakota, I often on a legal drain project couldn't tell you a dollar value that's been calculated for the increase in benefit from the project compared to the cost. But in North Dakota, that exact estimated dollar value must be shown. The way they do that in Minnesota is through the appointment of viewers who are just by statute 3 disinterested residents of the state who have qualifications to assess benefits and damages. Sometimes I hear people call them mass land appraisers. That's not technically what the statute requires, but that's sometimes what they call themselves. And they work hand in hand with the engineer to determine the dollar value in benefits to each parcel and to recommend an award of damages to each parcel, again, which has to be required to acquire that right of way through the procedure. There has to be a recommended value of the damage that needs to be paid for acquiring that right of way. There's a couple of theories upon which they can determine benefits. The most common one is a theoretical increase in the market value of the property that's created from constructing the project, an increase in the potential for agricultural production, which is also tied to land value, but that one is calculated through calculating how much income can be earned off the land because of the access to water management. And then also an increase in the value of property that's created because now the land potentially could be subject to a different land use. Then there's a second theory which also allows for a calculation of benefits based on a land's contribution to increased sedimentation or the requirement of increased drainage system maintenance and capacity because the natural drainage on the property has been altered. There's some case law in Minnesota that says if land is so high in elevation, the speed and volume of runoff might not be increased by the drainage system that's in the low part of the system or of the watershed. And so some landowners historically were able to appeal themselves out of the assessment area by showing that their land was at an elevation that didn't actually benefit. And so the legislature responded by saying, well, there is still some benefit because you are contributing sedimentation and causing a need for increased drainage system capacity or maintenance because of accelerated runoff. If your land's in a natural condition, that might not apply. But if you've modified or altered the drainage, the legislature created that basis for assessing benefits. So with that, I better stop and ask if there's any questions about legal drains, about viewers, before I give a very short, it's not very long, but kind of short overview of the environmental regulations.
Again, people need to unmute themselves since we have muted everyone. So if you want to speak up, hit the unmute button, and telephone users will unmute you at the very close for you to ask your questions. But I have none on my list, Kale.
Okay. Either that was really good or I lost people. I'm gonna guess it's the latter. So we'll move on and give them time to think about questions before the end here. So I just want to touch on some very brief environmental regulations that apply. The first ones are federal, so they apply no matter where you're located. The Clean Water Act, these are something that you need to think about, whether you're a private landowner doing drainage, whether you're a road authority, whether you're a water resource district doing a public water management project. The first requirement of that is Section 404 of the Clean Water Act. It's enforced by the Army Corps and the EPA, permitting done by the Army Corps, enforcement being done by the EPA. And in statute, it says a permit's required to discharge dredged or fill material into navigable waters. Those are highlighted because they're both defined legal terms. Discharge of dredged or fill material being one that is governed by a lot of regulations, a lot of agency policy that's continually changing, and a lot of case law litigating over that term. I went to an environmental conference once and met an attorney who his entire practice was focused on those, 6 words. All he did was litigate on the East Coast about what constituted a discharge of dredged or fill material. And that was an entire legal practice right there. Of course, there's some exclusions in statute for normal farming practices, some soil and water conservation practices, agriculture, stormwater discharges, and maintenance of drainage ditches that don't require a 404 permit. This is an important one, I think, for people to understand. It's another statutory exemption for minor drainage. And it says it applies to not only maintenance of drainage ditches, but any discharge of dredged or fill material associated with an activity that has as its purpose bringing an area of navigable water into use which is not previously subject, does not meet this exemption and shall be required. So what does that mean? Well, the guidance basically says that if you are connecting upland crop drainage facilities, so this would apply to surface ditches primarily, that connection of that upland crop drainage facility to a Waters United States is exempt in regulatory guidance. That even if there is a discharge of dredged or fill material at the point that you're connecting your ditch to that water course that is a water to the United States, that is exempt. But the caveat is, if in doing so you drain a wetland and change that land use, and that wetland is a navigable water or is a waters of the United States water, then you no longer qualify for that exemption. Drain tile is interesting because depending on what state you're in and which regional Army Corps office they answer to, over the years I've seen differing opinions on whether a tile plow pulling drain tile through, let's say, a wetland that's determined to be waters of the United States because it's an adjacent wetland, whether or not that causes a discharge of dredged or fill material. Generally in North Dakota, the opinions I've seen out of the Nebraska Army Corps headquarters office have been no, that disturbance caused by the tile plow is not a discharge of dredged or fill material. So even if you're working in a waters of the United States wetland, you're not discharging dredged or fill material and therefore don't need a permit. Again, that's based on guidance, and that opinion might change. And then the second one being state-specific water quality standards. In North Dakota, these are enforced by the North Dakota Department of Environmental Quality. They can be found in the administrative code. I gave the citation there in the third bullet point. But these are basically the water quality standards of certain waters in the United States. This isn't really a permitting process, but it's a law in place that needs to be followed. And oftentimes, water resource districts or project components need to cooperate with the Department of Environmental Quality to make sure that their discharge is not exceeding the water quality standards for the body of water that's an outlet for that system. The ones I've been involved in typically involve some kind of gauge and reading that says you operate your drain when the levels reach certain standards or requirements downstream, where they're measured at that gauge. And then Swamp Buster, I spend a lot of time when I talk to private landowners about this. Again, the thing to remember is this applies to landowners and operators or their tenants who are enrolled in USDA farm programs, or as of the 2014 Farm Bill, who purchase federally subsidized crop insurance. And this prohibits landowners who are enrolled in those programs or by those policies from converting wetlands into cropland. And then there's an entire body of federal regulation, policy guidance, and NAD and judicial opinions about the exemptions and where they apply and how they work. On this slide, I've kind of outlined what my opinion is on where water resource districts need to be concerned about this. And I'll tell you that even within the agency and NRCS, this opinion has changed over time. There are NAD opinions out there that have applied these rules between landowners and water resource districts very differently in the 90s and the early 2000s than they're applied today. My assessment of the rules and the policy guidance today is that, again, I'm not saying don't consult with NRCS. I think that is a big service you can provide to your landowners. One of the issues you face is, as a water resource district, you cannot go to NRCS and get these certified wetland maps. They are protected under the Federal Privacy Act. And so you need the cooperation of landowners who are concerned about the illegal drains impact to their private property to cooperate with the water resource district during the design process to try to address those issues. The current state of law and supported by NRCS and FSA in North Dakota today is if a wetland is converted by a legal drain project that does not result in ineligibility for that landowner or that operator, but planting within the boundaries of that converted wetland might. And that becomes the issue then that if that landowner wants to plant within that boundary, they either need to mitigate that wetland or have the water resource district mitigate it as part of the project to avoid potential claim for damages, or avoid planting and plant around those acres that maybe they farmed when conditions allowed previously. When you mitigate wetlands, generally the Swamp Buster and the Clean Water Act accept the same mitigation. Again, I said generally, that can apply for both agencies, and sometimes I've been involved in situations where both agencies want the other one to make a decision first and then they'll support it. And so sometimes you just have to work through those and try to convince one to move. And generally, the other will follow. And then if you go back and refer to these are just, I get asked a lot about buffers in Minnesota, but this slide just covers some state-specific environmental regulations that exist in Minnesota. And we have quite a few of them here that I don't see as many of in the Dakotas. Again, the Dakotas are more focused on land use controls and then the application of federal environmental regulations. Minnesota has some state environmental regulations that are on this slide. So with that, I know that was a lot of information to get through, but maybe if Levi doesn't mind me going a few more minutes into his 90 minutes, maybe some questions have been drummed up here as I buzz through those last few slides.
Thank you, Kale. You certainly did pack a great deal of information into a short time. So thanks for working so hard to condense volumes of case law and statutes and regs into a comprehensive presentation. While Julie is opening up the phone lines, I have a couple of questions here. One is about the environmental regulations with respect to point source. It seems to me that the Department of Environmental Quality does regulate. Okay, that phone's not ready to be unmuted. Does regulate point source, like from a city or from a ethanol plant or something of that nature, the quality of the water that's being discharged. And there seems to be more of a point now with a tile pump or a sump that is discharging directly into a drain. Is there any movement or is a regulation or anticipated that would evaluate the quality of that water?
Yeah, I'd say the most recent movement that someone on the call might be familiar with is some litigation that was brought in Iowa by the Des Moines Waterworks plant, which is the plant that treats the water that serves the communities of Des Moines and some of the adjacent suburb communities. against their drainage districts, which is the closest thing they have to our water resource districts, but their drainage districts serve a much more focused role on just legal drains, where they attempted to, through litigation, show that those legal drains, which are carrying, agriculture, stormwater, drainage runoff to, in Des Moines, it's the Raccoon River, were not exempt from the water quality standards in the Clean Water Act. And they brought that case in federal district court, and the federal district court used a unique procedure to say, before I can hear this case and determine if these drainage districts are liable for this water quality issue, I need to certify a question to the Iowa Supreme Court and figure out whether drainage districts in Iowa have immunity from tort liability. That was the basis of the claim. And the Iowa Supreme Court ruled that, unique to Iowa law, drainage districts there were immune. They're a government entity. The government hadn't waived immunity, and they were immune from liability for torts. And because of that, they couldn't be sued for damages or for costs incurred for someone downstream to remove the water quality concerns from the water and to use it for, any source, in that case, drinking water. And then that case got dismissed. I think a lot of people were watching that case really closely, thinking this might finally answer that question, Lance, that you raised, but it didn't, and not on the basis of the question about water quality. And there's another question in the chat box to everybody about, can adverse impact be tied to salinity issue concerns? I think that's still basically on federal and state level, somewhat of an unanswered question.
I have one more question here, Kale. Do water resource districts in North Dakota need to review the project costs against the assessed benefit of the project development? You highlighted the numerical setup in Minnesota and the spreadsheet in North Dakota, but is that a requirement of moving forward?
Yeah, here's my opinion on this. And again, I'll admit this is probably a very unsettled and contested area of law. But my opinion is, if we kind of look at and break down what's in statute, in North Dakota Century Code, it says the Water Resource Board must find that the benefits exceed the costs. And so you'll commonly see in findings of water resource boards a finding that we find that the benefits exceed the costs. If you read the cases in North Dakota on judicial review of orders related to legal drains, a common response you'll see from the courts to that is that if you're questioning the benefits of a project, the statute says you have an appeals process to the state engineer, and then that state engineer makes a decision on benefit. But ultimately, if your appeal ends up one way or the other in front of a court, a common response from the judiciary is, we're not going to put ourselves in the shoes of the water board managers and the state engineer and challenge benefits by way of reviewing a specific dollar amount. And the courts will say that the legislature has delegated that decision to the water boards and to the state engineer. I think that there is potentially an argument about what the Constitution requires in terms of assessing someone for a special benefit project against their will, in this case, North Dakota, meaning against their vote, where they voted no, where it can be shown that the project costs are more than the increase in the value to the property that's being brought. And, so in North Dakota now we have this economic analysis, and part of the issue which exists in Minnesota as well is this is all theoretical. I mean, it's not like there's a universally accepted method of determining benefits. But there's a potential that you go through that economic analysis and you find out the economic ratio is 0.9. And my understanding is that means the State Water Commission's cost share policy will only give you 90% of what you would otherwise qualify for. But then the question is raised is, then are you taxing landowners for a project that costs them $1 for every 90 cents of value that it gives back to them? But again, you know, when it's cost shared, it's not like 100% of the project costs are being paid for by the landowner either. So I think it's, in my opinion, a very unsettled question, and some may think that it's not. But I think it's one that probably is worth looking at and considering and contemplating.
Thank you, Kale, for all those answers and for the presentation. Are any of the folks on the phone who weren't able to send in a chat or raise their hand, do you have any questions or observations while we've got your phone lines open? Anyone else, any closing remarks? I do see one here. Jeff asked if we could make the presentation available. I should have maybe mentioned at the outset that this presentation is being recorded, and so we will have the video, and part of that is, of course, we are making this course available for water resource managers in compliance with their training requirements, that every water manager is under statute required to have 3 hours of training. And so this 3-hour course would count for that. So we are logging the folks that participate, but understanding that people are busy and doing farm work and so forth, that it might be impossible for them to have been on this call live. So we will work to make these videos available by YouTube or some other similar means to have the access to this later, and then we can maybe figure out how to document that they've watched the videos for training or for other purposes. It looks like you have one final question, Kale.
It says, do you feel a landowner agreement holds the same legal weight of an easement? I'd say if the landowner agreement is oral, then no, because the statute of frauds requires it to be in writing. If it's in writing and it is not recorded, it is still enforceable as long as the parties to the agreement are still the landowners. But it's the recording of a landowner agreement against the property records and the agreement containing some, attorneys, we call it the magical language about the agreement running with the land, that makes it binding on future landowners of that property.
off with a virtual happy hour at the end of these, and we can